All right. Hi, everyone. Good afternoon. My name is John Dara. I'm here from the Ankin Law Office, and first wanted to say thank you to the Decalogue Law Society for having me here today, and thank you for joining as well. So my background, I am an attorney practicing exclusively in Social Security disability practice. I've been doing that for about 11 years at this point. Almost all of that, about 10 years out of the 11, I've been representing claimants at the hearing level in particular. I've done about 2,000 administrative law judge hearings on SSDI and SSI claims. More recently, now I'm working with claimants throughout the entire process at the initial application and up through district court when necessary. So I've kind of run the gamut in terms of what I've done representing claimants. I also did work for a year as an attorney advisor at the Social Security Administration back in 2018. So I have some insights in the process from the other side as well. Today, I put together this presentation with the assumption that most folks have done either little or no SSDI practice. So that will include an overview, but I wanted to talk about the process from start to finish as much as I can, but also talk about some of the many changes that have been taking place in really the last year, but certainly since January as well. So if you have experience at a more significant level with handling these types of cases, but you don't do it all the time, bear with me during the background. We will get into some stuff that's going to talk more about the recent changes at the agency level, both under the outgoing Commissioner O'Malley, who was with President Biden, and now since the return of President Trump, a lot of accelerated changes on staffing and how things are being done at SSA that have pretty significantly impacted the way things are done. So we'll go through all that today. I'll do my best to leave time for questions. If you do have questions that pop up while I'm talking, please leave them in the chat. I believe we'll hit those at the end of the hour. So just as an agenda to go over quickly here, I'm going to start out with a topic I think that doesn't get sometimes enough attention when talking about representing claimants in SSDI and SSI is just getting appointed. It's more labor intensive and can be challenging, and you can't do anything until you actually get attached to a case. So I wanted to go over that, and that's had some recent changes as well. We'll talk about the distinction between SSDI versus SSI, what those benefits mean compared to one another, where they overlap and where they don't. The sequential evaluation, which is the 5-step process that adjudicators go through in determining whether someone qualifies for disability benefits or not. We'll discuss some of those recent agency changes, again, both late last year and throughout this year, and then some of my own personal recommendations based on those changes. So it's a fair amount to cover. And again, I thank you for being here and listening today. So starting off with just the bare bones, getting appointed. Again, a lot of the time when I was learning how to practice this area, a lot of the focus is on the definition of disability, what to do when you have a case. What we don't talk enough about is how to get attached to a case. And it's not easy, and it's getting more difficult in a lot of ways. So things to be aware of if you decide to take on an SSDI or SSI claim. The process of becoming the appointed rep and filing your appearance, so to speak, is disproportionately time consuming. It's not quite as simple as with a public proceeding where you can file an appearance and then you get attached and it's public record and you can see things pretty much right away. This is obviously a lot of protected information. It's all protected information, highly so. So with good reason, we can't get into these case files easily. But there's also a lot of administrative snags that can happen. So, indicate here, assume that you'll be making multiple follow-up phone calls and likely submitting documents multiple times. I have my little aside here about DOJ, the recent controversy about how easily they're getting access to a lot of sensitive data, when in reality, it's quite hard, even as an attorney looking to get involved in a case, to be appointed and get that access. And that can be an issue if you have somebody who has, statistically it doesn't happen as often, but a person who might be a candidate for an approval at the initial application stage, it's possible that these appearances get so delayed that the decision is out before you get attached to the case and you're not receiving correspondence and things that you need. So a lot of time up front needs to go into that. And there are several things required. One of these gets into our changes right off the bat. So the form SSA 1699, that's a registration form with the SSA to allow you to become an appointed representative, whether it's attorney or non-attorney. As of September 30th of last year, that's required for all representatives to complete, even if you're waiving fees. So if you're somebody who in the past has done a pro bono case and waived fees, you didn't have to do that 1699 form, but now you do. And it's mostly just your personal information, registering yourself as an approved representative, but it has to be done before you can complete anything else. Once that's done and you're on file as a registered appointed rep, then there's other documents that would be strongly advised, but the main things that you need are your SSA 1696, which is the appointment of representative form, which we'll get into on the next slide a bit more, and then a valid fee agreement. Generally speaking, if you're seeking a fee for representation in these cases, then the regulations of the Social Security Administration will indicate what the maximum fee can be, and that's 25% of any retroactive benefits awarded to the claimant up to a cap, which at this point in time is $9,200. So the 1696, that's our appointment form once again. Historically, that's been something that you filled out by hand. You could type out a PDF. A lot of times you would make amendments with a pen at the hearing office to add your name as a secondary rep if somebody from your firm was already on the case. As of December of this year, that can now be done through ssa.gov. They have changed both the way of completing the form and also the content of the form. So if you've done a 1696 in the past, be aware there's additional information that you have to put on there, which we'll get into. But also you can do this electronically. So whereas for many years they wouldn't accept electronic signatures on documents for SSA claims, now you can do this through Adobe Sign. If you have a client who's email savvy and you have their email address, really all you need is their full name, their social security number, their zip code, and then your own name and rep ID that you get from registering with a 1699. You send them a document protected, a password protected document, password of your choosing. And then I put the note here, in theory, this is faster. In practice, so far it's not. It's nice because you complete the form, it goes directly to the SSA and they have it. What's happening after that is not clear. I know that at all stages of the process so far, I've had the experience of completing the electronic form and then needing to then fax it. So it's a little extra redundant to submit something directly through electronic means and then have to send it via fax. But I just ran into it where I took a case, I believe it was last month, for a person who's scheduled for a hearing in May. We completed the electronic 1696 immediately. And as of yesterday, I still had no access to their file. And so we had to fax the form. And then within 24 hours, I had access. So I think it's wise to use the electronic version whenever you can, but just assume that they're still working out the kinks on their end, and you can't trust that it's just going to get done the right way once you complete it. And then as a note, you still can do a paper form just to begin with and fax it. I like doing the electronic and having a record of it personally, but you still have the option to do it the prior way as well. In terms of the content, the changes to the form itself. So this is a new change as of late last year. It's a good one. For a long time, the rules were that even if you appointed multiple attorneys from the same law firm, you couldn't just appoint a law firm. And you still have to put your own name on the form, but you can assign your fees to your law firm. So in theory now, they're working with us on being able to say, okay, this is the firm and a couple different lawyers might be on it. Whereas in the past, if you had a new attorney from your firm take the case over, you could run into fee petition issues and they would make you submit a fee petition for two different attorneys to say who should get paid, even though you're from the same office. So they've kind of bettered the efficiency there with this new option to assign. You also have additional duties on the form. You have to indicate whether you're representing the client for SSDI, SSI, both. There's other options as well. We're not going to get into some of the other types of claims today, but widow benefits, dependent benefits, those kind of things. You have to indicate on the form exactly what you're representing them for. And then again, I've already touched on the belt and suspenders that do it electronically, but plan on submitting it a second time as well. Which brings us to, okay, so you're appointed now, and now what? What happens next? So you've spent the days and hopefully not weeks and months getting access to your client's file. However long it's taken, now you're there. What does it mean to be disabled under the SSA's regulations? So I broke it out by element. That's kind of a mouthful. The definition of disability being an inability to engage in any substantial gainful activity, which has its own meaning that we'll get into, by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So you have to have all those things. You can have a very significant medical impairment, but if you're still engaging in substantial gainful activity, which means working and making above a certain level, no matter how unwell you are, if you don't have a 12-month period with the requisite income level, then you would not qualify. You have to have all of these in place. And this definition of disability is going to apply to both SSDI and SSI benefits, but there are some differences between the two. So I discussed that here. Once you've gotten appointed, you want to figure out, ideally, you know when you take the case, but sometimes you don't know until you get in a file. A client might not have the best recall of their own work history. They might not really know whether they paid into Social Security or not. You have people who worked but did not pay taxes or did not pay into Social Security, and so they're not eligible for SSDI where they thought they might be. It happens fairly often. So going in, doing your intake screen, you want to try your best to get all that information up front, but even someone who's trying their best might not have an accurate description of that. So now you're in your file. That's when you can see what the SSA sees. You can see the earning history and different documents that will help you determine that. So,
Excuse me, John. We don't see your PowerPoint. Are you running your PowerPoint? Because the screen's not being shown us. Okay.
Was it never showing it?
It has not been showing it. I'm sorry. I was taking care of letting someone into the room. So I would have let you know earlier, but yeah.
Interesting. It says I'm screen sharing. Let me stop and try to reshare it. I'm sorry about that.
Oh, actually, Helen says she sees it. So apparently it's just on my end, but that means that it's not going to be on the recording.
Okay. All right. I need to reshare that. I'm sorry about that. So everyone's seeing it?
It shows now. Yes. Thank you.
Okay. I see a lot of I sees it. It's back. Okay, cool. Thank you, everyone. I'll try and keep the chat up and make sure I see if it goes away again. All right. So we were talking about the type of claim, SSDI versus SSI. The key term there is what we call the date last insured, or the DLI. That's a critical piece of information. And so this is a bit of a dense slide. I won't necessarily go through all of this right now because there's differences between the age of your client and their work history and how many work credits they need. You'll see the term qualifying quarters used interchangeably with work credits. Basically, you need to have worked enough and paid into Social Security enough to be in insured status. And this is confusing for clients too. I spend a lot of time explaining this to the folks I represent because they will see something about what's called their date last insured in the documents, and they think it means that their health coverage might end at that date, or any number, or their benefits, if they're approved, will only pay through that date. And what that means is basically, if you think about it as like a claim period. So for most folks, if you've been working steadily for a period of years and then you stop working and you've been paying into Social Security all that time, you get a 5-year window after you stop working, is the easy way to think about it. But some people have work histories that are maybe they have disruptions for a variety of reasons, where they took a stop from work and then came back. So the way it's calculated is that they have to have 40 qualifying quarters period to be insured if you're over age 31, and 20 of those have to be in the last 40 quarters, the last 10 years. So there's actually a report that you can see in their file that will show you each quarter, whether it qualifies or not. It's a pretty low threshold for income that you have to earn in order to qualify for a quarter. It does not have to be full-time work. That will impact how much their benefit amount is, but in general, it's, do you have a qualifying quarter or not? And do you have 20 of them out of the last 40 quarters? And then that will dictate the DLI, which is basically the end of a quarter during which you were last eligible to receive benefits off your wage record. So again, if you're working consistently, you're going to be insured into the future. You will have situations where somebody maybe stopped working just a year ago, but they had enough of a gap in on and off through their work history that their insured status might have expired 2 years ago or 3 years ago. And in those cases, you're having to prove then that they became disabled prior to that date last insured, 2 or 3 years in the past. Sometimes that's a person who has had problems with their health for years, but didn't know they could apply or didn't want to apply. And so you may still have evidence going back to that date to prove the disability began before that time. Others, they just weren't having health issues back then, and then they weren't working for other reasons, and the date's too far in the past. And so if that's the situation where your date last insured is, 4, 5, 10, 20 years ago, that's a situation where SSI would be the available benefit for them if they're lacking sufficient credits, which is if you're someone who has never worked, or you have worked minimally, or again, you've had a long break, or someone who worked for cash. You see a lot of folks who have been actually working very hard for a long time, but they weren't paying into Social Security, often not really knowing the difference between doing it or not. And they lose that insured status, and their only available option would be the SSI benefit. Now, I note here that SSI, it's the same definition of disability. It also comes with a pretty stringent needs-based component attached to it. So the benefit amount is lower. It's just over $900 a month right now, and they offset. If you're having any kind of income, they reduce it. $1 for every $2 you're making from work. You have to have no more than $2,000 to your name in any account, including like life insurance policies. So it's a very, very stringent with the needs-based portion of it. So if it's possible to be insured, that's the better route. SSDI is a more flexible benefit. It's a higher pay benefit, and it also confers Medicare as well. But you want to know what you're looking at so you can advise your client properly. You want to know, do I have to get a doctor to tell me this person was disabled before the date last insured, even though they weren't treating as much, that kind of a thing. So it's very good to know that up front. All right. So now we're on the case. Ideally, we know what kind of case we have. We want to get into the 5-step sequential evaluation. So as I mentioned at the outset, this is the process that the adjudicator goes through to determine whether a person qualifies for benefits or not. I always advise you want to think the case through in the same order that the adjudicator does. So if you're taking a case and you want to represent somebody for benefits before the SSA, when I was starting out, my gut was always, give me the medical records. Let me get into the file, figure out what's going on. Why can't this person work? Really, the first thing you want to sort out is any work activity, because that's the first thing that your adjudicator or the judge is going to look at. And if there's an issue at step 1 with the work activity, then that's the end of the discussion. So make sure you don't spend hours reading through 5,000 pages of hospital records, and then you find out that this person has an income that disqualifies them. So step 1 is the claimant engaged in substantial gainful activity. It's a term of art with a specific meaning. The short version is basically, are they working? And as I note here, it's really a counting test. For this year in 2025, the threshold for SGA, substantial gainful activity, is $1,620 a month in gross earnings. And so always stress that to your client as well. People like to tell you their take-home pay. SSA is not looking at what you net. They look at what did you earn before taxes and deductions and anything else. You can still be working so long as you're consistently under that level of income, and you would have a viable claim. But it makes it much more complicated. It's a little easier if you have a person who's closer to retirement age and bringing in a limited income at a lighter duty job, and their work background was rigorous and physical. You can work with that. It's pretty hard if you have a younger person who's making, say, $1,500 a month, and the adjudicator is going to look at it and say, well, they're pretty close to the line. Are they just trying to stay under it on purpose to keep their claim viable? So it's complicated if you have income. It's easier representing the case when there's no income. It's also much harder for a person to survive the lengthy process. So it can get thorny for a lot of folks. And you'll see income a lot. It's going to come up. People will try jobs and they have to do what they can to survive this process. It can take a year or two before they get an answer here. So self-employment, not going to get into that today. That's its own CLE, but it's more complicated. There's different tests that will be looked at beyond just, is the money above the line or not? But just be aware of that if you have someone who has a self-employment income during the period that you're looking at. And then you need that period of 12 months, as we saw in our definition up front. You have to have a 12-month period without SGA. So again, that can still be someone making some money, but it needs to be 12 months or longer without going over that line. And then just as an aside here, a lot of folks get confused on this, asking about temporary or partial or a short-term disability. Those are not options under the SSA. You either qualify or you don't. So if you have a period where a person was unable to work for 6 months, 7 months, that's a horrible situation. We have to tell them there's nothing we can do here, but if you're back to work by that 8th month or the 11th month, whatever it might be, there's not an option there. And I have run into that. I've seen people actually start back to work within 2 weeks of their 12-month period, and they had no claim, unfortunately. So look carefully at that. Step one. And then if you survive step one, of course, on to step two. Now we get into the medical records. So we figured out, okay, we have the requisite level of reduced earnings or no earnings for 12 months. Now we look at the medical file. And here we're looking at, does the claimant have a severe medically determinable impairment? The definition of severe here is different. It changes during the course of this process. So at step two, when they say severe, it does not mean the doctor wrote it's severe. What they mean here is it has more than a minimal impact on the ability to perform work activities. So it can be a fairly mild degree of impairment. Impairment's the word that they use for it, but if it's enough to affect work activity, then that's enough. And they also can and will look at non-severe impairments and consider those in combination as well. These need to be established by objective medical evidence, so you can't just present a list of symptoms or subjective statements. You don't want to apply for benefits saying pain. You don't want to say I'm tired and I have pain. It needs to be, pain because of X condition, and the medical records need to establish that. So we can't self-diagnose on those things, and that can get tricky, but that's where consistent medical treatment is key. And then again, the impairment itself, in addition to the lack of work, the impairment itself must last 12 months or be expected to, or that it will result in death. And so this is a situation where, say you have an injury, maybe not a chronic condition, but a bad injury, and fortunately the person has a good response to treatment, and they go through a surgery and physical therapy, and then by 9 months they're back to normal or their prior baseline, then that's not a severe impairment. It didn't last the 12 months. If there's no severe impairment found, then that's the end of the analysis and the person is found not disabled. If there is even just one severe impairment established by the record, then we go on to step three. Step three is the analysis of the listings. So you can meet or equal the listings. It's basically just a giant book of medical conditions the SSA has set aside with particular criteria. And if you meet the objective evidence on each subpoint for the listing for that condition, then you are disabled per se. So if you are meeting any of those at step three, then that's the end of the analysis and it's an approval. These are highly technical and medical. My experience has been that most people, if they meet a listing, it's significant enough that they get approved at the first or second stage of application. So you have your initial application, then reconsideration, and then your hearing level. Those are kind of the big three. Folks who meet listings tend to be the small number of people who are approved up front. It's a little less common at the hearing level, but it will happen. And unfortunately, sometimes people will progress to a point that they meet a listing by the time you're at a hearing. But again, these are very evidence-based. It has to be objective evidence. The analysis is fairly technical, and the listing will tell you, exactly what you need to see on the testing of lung capacity, or exactly how many hospitalizations within how many months you need to have for different conditions. So meeting it's pretty hard. You can be found to equal it. So if you have a claimant who doesn't hit, say there's 5 criteria and they hit 3 or 4 of them, but then one of them is so bad that it kind of offsets the fact that they're not hitting the other 2. In that situation, you may have a medical expert who would opine, they don't meet it, but they functionally do. They equal it, and that can lead to an approval as well. But it's all based on the records. At a hearing, a medical expert might consider testimony. That tends to happen more with psychologists and mental health experts, but don't bet on it. Most of them will say, well, it's not in the record, so I can't opine on it. Maddeningly so, even when it's clear, they won't. So, and then again, if you're meeting or equaling the listing, then your claim is approved at that point. Claimant is found to be disabled. Some of those listings will have a prescribed period right up front. Like, for example, if you are getting a liver transplant as a claimant, then you are automatically found disabled, and also for the next 12 months at minimum. That happens with other conditions as well. So you want to make sure you review any listing that may apply based on the medical conditions at issue. Don't disregard this section at all, but for most folks, assume that you're going to be progressing past this point. Most folks don't meet the listings. Which brings us to what I call step 3.5, kind of, the residual functional capacity, the RFC. This is an interesting thing because really it's kind of the biggest part of the process as far as the evaluation goes, and it doesn't get its own step. So everyone is kind of refers to it as step 3.5, but this is where the adjudicator will, based off of medical opinions from claimants' doctors, from SSA agency doctors, from whatever they have in the evidence subjectively, they will assess the residual functional capacity, which is the most that a claimant is capable of based off medical evidence for an 8-hour workday, 5 days a week. And then you can see I list here a variety of categories. This is non-exhaustive, but standing, walking, lifting, carrying, bending, twisting, and so on. They have to consider every capability. How much can this person do? They rate these things typically in terms of constant, frequent, occasional, or rare or seldom. Usually it's going to be looked at in terms of frequent or occasional if there's any kind of impairment at all, with frequent meaning basically up to 2/3 of the day, occasional up to 1/3 of the day, but not more. And so there'll be a rating in each of these categories, and then considering things like, can they be exposed to moving mechanical parts, to odors and dust and fumes, considering the mental ability to focus, to work with others, respond appropriately to feedback from a supervisor. So it's a very long list. And if you're at a hearing, you'll see that the ALJ will typically go through, at least a couple of those hypothetical RFCs, and sometimes as many as 6 or 7, slightly tweaking and adjusting different domains. So, here they can stand for 2 hours out of 8. Now they can stand for 4. And then that will yield different outcomes potentially in the kinds of jobs that may be available for that person. So that's really what we're looking at when we're representing a claimant on the assumption that we can't meet a listing. We're trying to establish what is the RFC finding we need to strike out their past work and other work, and what evidence do we have to support that. So if this person's been working on their feet all these years and now they have trouble standing, we need to get a finding that they're limited to sedentary work. What's going to support that? That's what we're looking at for the RFC. And then once we have the RFC, we get to step 4 and 5, which sort of work in tandem. There's a difference between the two, and there's a burden shift as well. Up through step 4, the burden is on you as the claimant to prove that you should proceed to the next step. And then at step 4, the situation is, does the RFC allow them to return to any of their past relevant work? And so we have the duty to rule out our ability or our client's ability to perform any of their past relevant work. Past relevant work also has a certain meaning, and so that's going to be jobs that were performed within the requisite recency. We'll discuss that in a minute when we get into the changes at the agency. But it has to be recent enough. It has to have been done long enough to learn the job according to the skill level of the job. And then it had to have been performed at that SGA level. So whatever year it was performed in, each year has its own SGA level. So if it's a job from, say 2018, you need to know what was the substantial gainful threshold in 2018. Did they earn that much doing it, so that job could be considered. And so then all the jobs that meet those criteria are compared to the RFC. If the RFC says that you can return to any of your past jobs, then you are denied at that point. If the RFC says that you cannot return to your past relevant work, then you proceed to step 5, and that's the ability to adjust to other work. And so there we're looking at what's called occupations in significant numbers. And as we so often see in the law, that's a term that has a specific meaning, but it's not really clear what that means. So a lot of debate in these cases is about the significance of the numbers. Is it a job with the numbers that are big enough? It used to be regional and national numbers. They've really gone away from the regional number, and they focus now on numbers in the national economy. So, if there are 10,000 nut sorters in the national economy, is that enough? Is that significant? And you'll have some judges who will say yes, and others who will say no. There's no bright line on that. The case law is also a bit all over the map on this. I know there's one case that I like to rely upon where the total of 3 jobs that were cited were, I want to say 32,000 between all of them. And a district court said that was, a close call. 30,000 might not be enough. But again, there's no bright line on that. So be prepared to get in the trenches on that. If you have a finding that there are no jobs in significant numbers, or maybe 1 or 2 jobs, and there's only 1,500 of each of them in the national economy, then at that point you get your party emoji. You've done it. You've gotten your client approved. But of course, it's not that straightforward. I did put a note there: grid rules, be familiar. Again, that could be its own discussion, but the grid rules are the colloquial term for it's the medical vocational guidelines within SSA's regulations, and that's they love the grids. The adjudicators love the grids. Those apply to anybody who are age 50 and up, generally speaking. There's a couple of narrow exceptions there, but generally it's if you're over the age of 50, they can look at a grid that's kind of a decision tree and look at your age, your work background, your RFC, and it will direct them, is this person disabled, yes or no? So if you have somebody who is age 50 and up, be thinking about the grid rules, be familiar with them, and highlight what you can to get the RFC that puts you in the right category to get the approval. A few more words on step 4 and 5. So if you have past relevant work that was skilled, you do have to consider the ability for skills to transfer to other jobs. Again, could be its own hour-long discussion, all of that, but that's harder to lose that argument if that claimant is 55 or older. They have to consider the ability to adjust with almost no additional training or education on jobs like that when they're 55 or older. But if you have a younger age person and they've acquired skills, they will deny them if they can go into something, even if it's not directly comparable work, and they don't have to consider their income or is the job similar when it's a younger age worker. So if you're a younger professional and you suffer a medical setback that doesn't allow you to perform your job anymore, but you can do entry-level work, according to Social Security, you're not disabled. SSA still uses the ancient Dictionary of Occupational Titles as the authority for classifying occupations and how they're performed. That's been a hot topic for many years at this point. That was last updated in, I want to say it was 30 or more years ago at this point, since they updated any of the jobs in there. So a lot of jobs that are out there now in the economy are not even in the DOT, and vice versa. There's jobs in there that don't exist anymore. And, elevator operator, things like that, where that was a job that had numbers at one point and now it really doesn't. So they've been working to try to figure out a way to deal with that with their with data from the Bureau of Labor Statistics. It's a work in progress. What they've instead done more recently is a new SSR 24-3P in the Social Security regulations, which is basically now allowing that a vocational expert can testify and they can diverge from what it says in the Dictionary of Occupational Titles and then say, you know, I considered XYZ and I have experience, and so that's enough. So that's been a new hurdle for us to deal with, and is a bit of a meaty topic. And there's a lot of brand new trainings that are focusing on just that issue. Most of the vocational experts are using the SkillTran Job Browser Pro for their job numbers. There's a lot of going back and forth on, you know, how good is the methodology for those job numbers, how much can you challenge them, but really, as of right now, with this new regulation, it feels like the VEs can pretty much say, well, I know the DOT says a document preparer uses microfiche, but my opinion is that the people doing the job now, it's no different, even though they use scanners and laptops. And judges are taking that at face value a lot of the time, unfortunately. So be mindful of that update in the regulations, which brings us to the other many recent agency changes. So hopefully you guys are still hanging in there with me as we've gotten through the meat and potatoes of the process. But as I mentioned before, both last year and this year have been busy times of change. And that's been under both the former Biden administration and now the Trump administration. So we touched on it earlier, the 1699 being required, that's new. The 1696 having its own substantive changes is new. The fact that you can do it electronically is new. Electronic signatures were not a thing until COVID protocols went into place. Neither were remote hearings, and now those are both the norm at this point. There's been an increase in the fee cap. So the cap for what a fee could be for an attorney was $6,000 for a long time. That's what it was when I started in 2014. That had already been in place for decades at that point. It didn't change until 3 years ago when they bumped it to, I think, 7,200, and now it's 9,200, which is good. It's encouraging people to be able to take these cases. It's hard to represent somebody, and if you're not doing it pro bono and it's a way that you're planning on doing business and bringing income, you need to be able to afford to do the business so you can help people. And so there was a lot of support from the disability attorney bar on that to get that fee increase. A major change that went into effect last year, and this is a claimant friendly one under former Commissioner O'Malley, was a change in the past relevant work and how that was assessed in terms of the recency. So for the longest time, the rule was that any job performed in the last 15 years was fair game for consideration as a past job, and could the client return to that? So you did see situations where, you know, it's 2023 and this person has been working for, you know, 12 years as a say a cashier, and now they can't stand anymore, but they did a sit down job in 2009 and they're limited now to sedentary work, but they did that 14 years ago, so they're not disabled, which was leading to pretty absurd outcomes, and especially I think more so now with the way that technology is changing jobs and how they're done. Even something 9, 10, even probably 5 years ago, some of these jobs are very different in how they're performed now. And there was a recognition of that finally at the SSA, and so they changed it to only a 5-year look back period. Now the important thing to note here is I have the third bullet point down, that they look back 5 years from the date of adjudication, not the date of the application. So a job that was within 5 years when the claim was initiated may be outside of that window by the time you get to a hearing, if you're making a case to an ALJ. The flip side of that is if you have a date last insured that's in the past, they go 5 years back from that. So if a person's date last insured was the end of say 2023, then any job from 2018 and onward is going to be in play there for that step 4 for the past relevant work. But if you have a client who's insured currently and into the future, then only jobs that were performed in the last 5 years can be considered. And that makes it considerably, I think, more common sense. Again, not making someone have to entertain the fact that they could perform a job that they hardly remember. It also, I think, streamlines the process a little bit. The work history report that you have to complete, the work testimony, is much more concise and accurate when we're not asking people to remember what they did at Walmart in 2011 and it's 2015. It's just difficult to be accurate on those things. Now, for most folks, it's a job, maybe 2 jobs have fallen in the last 5 years. And the thing I would point out for folks there too is be aware as the practitioner, if you have something that is about to age out of that 5-year window, raise that point. You raise that point to the adjudicator because they take a long time. You may have a hearing where a job was within the last 5 years, but by the time the decision's written, probably it will not be. I just had that situation arise recently where it was a hearing this month and this person has a job that come June, it's going to be more than 5 years since they did it. And it's a fair bet that that decision won't be written before June. And so I asked the judge to take notice of that. And, you know, a judge that I know won't hurry up to my detriment, but would rather be reasonable about that. So, but again, it's a great change for claimants and better reflects the realities of work. Another change here is the clawback of overpayments. This is probably going to be something to be more aware of if you're planning on doing, you know, pro bono, helping folks with overpayments. But this has changed twice. And so it's my last point, but the perils of politicizing a bipartisan agency, which we've come to, and then some. Under the last administration, there was some easing of how they collected overpayments. So say a person started going back to work, they had an increase in their income, their benefit should have ceased or been reduced in some way. If the SSA was not aware and they continue to overpay, then it used to be that they would offset your benefit up to 100% until the repayment was satisfied. That was reduced to 10% last year. And then promptly this year was put back to 100% for SSDI. They did leave it at 10% for SSI, which is at least a good thing there. And I think very critical because those are folks at a lower income level and getting a lower benefit. But we've kind of ping-ponged back and forth on the issue here with the overpayments and recovery of that. Some of that had to do with during COVID, field offices were closed. A lot of services were not available. There were people who were trying to report that they had gone back to work and they couldn't. And so they had overpayments, and that's ended up becoming its whole class action issue on how they've handled those. But it put the overpayment stuff back pretty firmly in the bullseye here. So now we're back to 100% recovery if you're working with someone who gets SSDI. And then bringing us more into the last few months, sweeping changes to the structure of the SSA under President Trump and the as of yet not confirmed commissioner. We have an acting commissioner in place who has done a lot, much more than you would expect of an acting commissioner. Kind of every day there's a press release coming out about a big change happening, and that's been with the involvement of DOJ as well. I'm sure folks have seen the headlines on this, and you can imagine I've been very glued to those, wondering what agency I'm going to be dealing with for my career today versus tomorrow. So they've consolidated 10 regional offices into just 4. The required return to office. So many folks at the SSA had continued to work from home or hybrid. And then my understanding from communicating with folks is that was pretty successful. But they're required to go back to office, which has led to some resignations, more than some. And they do have a stated goal of reducing the workforce by 12% at the SSA. So many of those folks who are not being let go and resigning are being moved into new positions. SSA is portraying this as a way to reduce the workforce significantly, but also still reduce the timelines for decision making and wait times on the phone, which sounds great. All of that sounds great. Ostensibly, there's a focus on putting a lot of folks into the public facing positions to deal with phone calls, be at the office, less of the behind the scenes work. It remains to be seen how well that's going to go. There's been some question as well about what you can do by phone. They just clarified you can still file for disability as a claimant over the phone. Oops, sorry about that. But that may change, and you can no longer do things like change your banking information by the phone. So for folks who are not as tech savvy, this is going to pose interesting problems, to say the least. They're trying to push people to use my SSA or go into the office whenever they can and reducing how much is on the phone. But then also they're shutting offices and reducing the number of staff. So how that's all going to work, to be friendly, we'll say that remains to be seen. The fear is that there may be a temporary boost where it's going to actually help with the phone getting answered faster, but there's going to be so much attrition and other things that are failing behind the scenes that it's not going to be sustainable. So again, the impact of these changes is yet to be seen. My experience so far is that the wait times are getting worse. They were already not great. There was some improvement with some of these things toward the end of 2024. It's been pretty bad. If you call the main SSA 1-800 number, first of all, don't. But if you do, they tell you up front your wait time may be 2 hours. You're better off trying to find the field office phone number for your local office. Those are intentionally hard to find. They don't always have them on the office locator through ssa.gov, so you have to find them through other websites. I've honestly found them through like Yelp and places like that sometimes, but you're better off calling a local office. The main line, you'll wait forever and then get cut off. And so that's getting worse. The morale of the agency staff sounds very low. You can hear it in the voice. And so I'm trying to be extra kind to them when I'm dealing with them, because it doesn't help anybody if we're pummeling them when they're already down. But it doesn't seem like it's going well there. Areas of concern moving forward. So we know the Doge department or group of people or whatever they're officially considered at this point, they have their focus on fraud, waste, and abuse. My concern is, does that lead to even higher scrutiny on claimants and beneficiaries with valid claims? It's actually very hard to get approved for benefits. I've been doing this a long time. I have worked with every kind of person. You can get a feel for when somebody maybe is making more of their situation than it is. And I can't think of a time ever that I had someone who's been approved for benefits and thought, I think they were, milking that. It's not easy to sneak a fraudulent claim through. It's already pretty scrutinizing. And the concern is, will that get worse as this process continues to develop? So it feels like in general, this community is even more under a microscope. And so I would suggest, if you're going to get involved on a case, that you really keep that in mind. You want to make sure that you're, mindful of the fact that this is a person at a low point, and now, everything that you see in the news and hear about in the political zeitgeist is how they're such a problem. This whole thing is such a problem. It makes a already difficult process that much harder to go through. And then just some recommendations I put together. I actually sent out an email to every client on my caseload last week, summing up some of these thoughts, just to talk about, what's going on and let people know that we're thinking about it and aware of it. And small steps that you can take now to try to, get around some of the things that are coming up here. So as I mentioned a moment ago, it's very clear that the agency leadership and the Doge folks want to make things either online or in the office only. So to the extent you're able, you want to help your client be as tech oriented as they are capable of. That's not going to work for everybody. And we have to understand that, but the My SSA account is a valuable tool if they can work that. It does require registering through login.gov or id.me in order to have that account. So you need to have a valid ID. They'll take a picture of you to match it to the ID with facial recognition. But if they can clear that and get through there, it's actually a nice tool. They can log in, they can see the status of their claim. Sometimes they tell you, hey, look, I see that a decision is out and I don't know that yet. So take advantage of that, help people get registered if you can. Along that same vein is My Chart and patient portals. Don't rely on the SSA only to get the medical records. They want to get them on their own because they want to know they're getting everything. And so they're still going to do it, but they're going to fail a lot and they're only getting more short-staffed. So you're going to run into cases where they send out 2 or 3 requests to the same doctor's office who never responds, and then they just give up on it. Or time goes on and on and on. You're wondering what the heck's going on with this case. And it's because of this one set of medical records. And more you're able to get these through the patient portal. I'll talk with my clients and ask them if, can we do this together? Can we log in and I'll download it right now and I could submit it to the SSA and get this done in 20 minutes instead of 5 months. So if they can avail themselves of that, that's great. Same with the HITMER program. This is another positive SSA development. They're partnering with more and more. This is larger hospitals and universities, but it's a growing list of electronic medical record partners where if you have a valid signed medical release on the SSA's form, it's the SSA A27. If you turn that into the SSA, they can download records from these providers almost instantly. The odd thing with it is that they will do it at the first and second level, but at the hearing level, they're only just starting to do it now, and you have to ask. And sometimes the judge will make you explain why you want it, even though you shouldn't have to. But it's worth the effort to pursue that because you can get these records at no cost to the client and almost immediately. And it's just a great efficiency there. And then I put in a note here that I shared with my clients too. It's always a good idea to monitor your credit anyway, but with the recent questions about PII and the data access, we have no idea. You know, I have no idea. None of us has any idea who has reviewed our SSN, our sensitive information, who these folks are, what their background screening was. I know when I worked there, it was an intense screening, and if I even looked up an SSN who wasn't on my caseload as an attorney, I could get the boot. So they take that very seriously, but it's been a different story of late. So the last thing these folks need is identity issues or false earnings on their record that messes up their case. So encouraging credit monitoring to keep an eye on that. And then lastly, you know, assume that the process will have a lot of delays. That's where I started this conversation, was the delays in getting listed as the representative, getting access to your file. Those delays won't go away. You're going to hit snags. You know, it's not uncommon in the law in general, but you're going to run into a lot of long periods of nothing happening. So do what you can to not create your own delays wherever you can. You know, just because the deadline is 60 days out to file the appeal doesn't mean we have to, you know, table it for 55 days and get to it later. If you're going to help someone with this, I would suggest do what you can to cut down on the delays on your side, because they're going to be there on the other side for sure. So final tips and takeaways. It's a Byzantine system. Prepare and be ready to be redundant. You can't get anywhere until you're listed, and that can take weeks or months. So make sure that you're submitting your documents, following up. Don't just trust to get it done. I've seen that happen many times where, look, I completed the form, I sent it, that's my job, I've done it. And then you're waiting for the SSA to do their job, and you can't just assume it. And that's not necessarily malicious on their end, but you can sit and wait and then find out a claim was resolved and you were never on the case. And so that's troubling for the client, embarrassing for the attorney. So make sure you follow up. Understand what your claim is. Is the person insured or not? Is there a DLI within a reach? Can we possibly prove an SSDI when we thought we couldn't? And then think that case through in the same order that the adjudicator is going to. So start at step 1, work it through to step 5. Don't get ahead of yourself. I certainly learned that the hard way myself, digging into the medical records when there was not a viable claim there. And then its own category off the side here, stay aware of the changes. This has long been a static agency. I mentioned I've been doing this for 10, 11 years at this point. For a long time, not a lot changed. And lately that is not the case. Things are changing on a daily basis. We're learning a lot through press releases on a regular basis. And so if you're going to get involved in a case with the agency, you want to make sure you're staying on top of that and keeping abreast of the latest developments. Assume each step's going to take longer than what it seems like it should. Give your client realistic expectations of the process and the timelines, and then cut your own delays wherever you can. So I want to open up to questions. I'll take a look at the chat, see what questions we have before I get to that. Thank you once again. My contact information is here. I'm happy to talk with someone if you're ever thinking about doing one of these cases and you have a question about the process or anything we talked about today or that I didn't go over. Feel free to reach out, or if it's to see if we can help out with a case or something. But I'm always happy to talk and teach about this area. I have a passion for it, so please don't hesitate to contact me on that. And with that, I will.
John, we have a question from Helen Black. She said she needs to say it orally. So I'd like to call on her first and then go to the ones in the chat.
Sure.
Thank you. First of all, John, thank you. I'm a fan of Howard, so it's good to know that you guys also do SSDI, 'cause it comes up from time to time, and that's the basis for the question I have you. So every once in a while in a comp case, a claim, I shouldn't say every once in a while, more often than not, or maybe that's not even the right word, whatever, a claim can be denied. And luckily I'm dealing with a professional and they have disability through work. But then the employer or the disability carrier, the long-term disability carrier has this requirement that they have to apply for SSDI to keep their long-term disability benefit. So you're shaking your head. So you kind of know where I might be going with this.
Yeah.
Is there any way to get out of it? These companies also have like these third-party providers. They're not even lawyers that say, we'll do it for you. We'll get the SSDI. They get them the SSDI. And I know these guys aren't necessarily qualified. It could be like a back injury where I know the recovery is more than 3 months, the STD period, but they're going to go back, or the recovery is just taking a little too much time. And then, on the comp side, I got to then deal with, set aside issues and all that jazz that I'd rather avoid if they didn't have to apply for SSDI. So do you have any thoughts on this scenario?
I share your frustration with it. As far as ways of getting out of it, not that I'm aware of. I formerly worked at a firm that primarily did the disability cases for folks who were LTD involved. And it's just a really standard provision in that world. And the problem is that most folks are electing that benefit. They take a job and they say, okay, sure, I'll pay the premium and I'll do that. And they have no idea what the terms are. Everyone's always very unhappy when they learn that they not only do they have to apply for SSDI, but then if they do get approved, they have to turn that money over to the insurance company as well. So it creates a lot of headaches. I'm not aware of any way to get out of it. It's unfortunately I think that you want to make sure they have good representation. There are firms with attorneys who deal with that, navigating the LTD and the SSDI in tandem. But it's they really push it. And the problem is that they do their own occupation first, and then any occupation review at the 2-year mark. And so a lot of these folks are being forced to apply for SSDI who won't ever get it because they don't qualify for a finding that they can't do any occupation. And so it ends up they're stuck going through the process, and it just becomes a nightmare with offsets. But I would say, encourage them to work. They don't have to work with the person who the LTD carrier recommends. It's typically a referral relationship, and that's it. So I would say if you're on the comp side running into that, encourage them to, consider they feel good about who they're working with, maybe find someone else. As long as they're pursuing the benefits, they're meeting the policy obligation.
Thank you.
Sure. Are there questions in the chat? Let me see here.
They're all at the end.
Okay. I have independent contractors. I don't know if there's more context for that I'm not seeing. There was a question about that maybe. That was Rebecca, if you wanted to add to that.
And Rebecca, you can unmute yourself. I allowed everyone to unmute themselves. So she asked another question. Maybe you want to answer that one first. Are expats eligible for benefits?
They can be. So that's some of these questions get into the more thorny particulars, but yeah, it's you can receive benefits when you're outside of the country. There's a few exceptions. There's a list actually through the SSA where there are certain places where maybe they won't pay. But generally speaking, if you're qualifying as a beneficiary and you've left the country, you continue to receive benefits. Let's see, Helen is who we just heard from.
Jack, I don't know if I'm sorry I called you Jack.
That's okay.
I was that your father? Was Jack there, or your father?
No, but I have jets in my family, yeah.
Okay. Everyone called Judge Dara, the federal Judge Dara, Jack Dara, and I immediately went to that. No relation. I asked a question about, I'm in family law. I asked a question about the child support allotment. Have you ever dealt with that issue?
When you say, do you mean for like an auxiliary benefit, like a dependent benefit, or do you mean like child support?
Yeah, right. I think I've heard it called the child support allotment in family law. And when you're on disability, apparently Social Security will actually pay $500 a month or something in a child support benefit. I'm not sure whether you're aware of that or not, but that's kind of a big issue in family law.
Yeah, the dependent benefit is, if you qualify and you have minor dependents, then it's fairly straightforward. It's just an application process generally. And they call it the auxiliary dependent benefit typically, but yeah, they'll go up to a certain family max per person. Again, the benefit amount itself, the term is PIA, is what they use for the worker. And so that's limited based off of how much you've paid in. We all carry our own number with us. And then you'll have a similar cap for the family up to a certain amount for the dependents as well. So, but if your client is approved, then there's I shouldn't say straightforward because there's, delays with all this stuff, but it's a matter of filing an application for the dependents, providing their SSNs, and you should be able to get that too.
Thank you.
And I saw that question was in the chat too. I don't think I saw any others that were in the chat and haven't been raised here. So does anyone else have questions? Or did I just perfectly?
Yes, you were perfect, John. Well, thank you very much for the presentation. Thank you very much for everyone who came. And again, apologies for the technical difficulties at the beginning.